A sweeping suppressor ruling just emerged, and federal attorneys executed a stunning about-face nobody anticipated. The Justice Department dismantled 90 years of their own firearm regulations, conceding that suppressor restrictions violate core constitutional protections. Over 2.6 million Americans who own these devices just won a battle most legal experts predicted they'd lose. Tap subscribe immediately. What's unfolding right now will reshape firearms law across the nation. The federal reversal. What transpired? January 20th, 2026, marked a watershed moment. Acting Associate Attorney General Benjamin Williams submitted a 47-page admission of error, essentially confessing the federal apparatus had trampled Second Amendment rights for nearly a century. This wasn't buried bureaucratic paperwork. Williams filed publicly in United States v. Patterson, declaring the department could no longer justify suppressor provisions under the Supreme Court's Bruen framework. Consider the scale of this retreat. The identical legal team that burned through 400,000 taxpayer dollars crafting a 156-page defense of NFA suppressor rules just months earlier in September 2025 was now systematically demolishing every argument they'd constructed. They acknowledged suppressors qualify as common use items with 2.6 million units registered nationwide. They admitted the $200 tax stamp creates financial barriers that exclude lower-income Americans from exercising constitutional rights. Constitutional rights cannot be priced out of reach. The capitulation extended beyond one lawsuit. Justice Department counsel filed position change notices across 6 different circuit courts simultaneously, pulling opposition from suppressor challenges spanning Arizona through Maine. Litigation that had dragged on for 3 years suddenly saw government attorneys filing concessions. But here's the calculated element everyone's missing. The DOJ explicitly stated this confession applies exclusively to suppressors. They're not abandoning defenses of machine guns, short-barreled weapons, or destructive devices. Federal strategists were making a targeted withdrawal on the most publicly sympathetic NFA category to prevent cascading defeats. And that's precisely where the Ninth Circuit panel declined to cooperate. The Patterson case, origins of constitutional challenge. Michael Patterson never intended to become a landmark plaintiff. He operates a competitive shooting academy in Scottsdale, Arizona, training law enforcement personnel and civilian students. March 2024. Patterson purchased a Silencer Co. Omega 9K suppressor for $650, specifically for hearing preservation. 15 years of firearms instruction had already inflicted permanent auditory damage. Patterson satisfied every ATF requirement. He remitted the $200 tax, submitted fingerprint cards and photographs, provided passport-quality images, notified his county sheriff, and entered the waiting game. His Form 4 application languished inside the ATF's National Firearms Act Division for 11 months and 17 days before approval materialized. The Firearms Policy Coalition approached Patterson about challenging not merely processing delays, but the entire constitutional foundation of NFA suppressor regulations. Patterson agreed under one condition: the case must deliver relief for all suppressor owners, not just individual plaintiffs. The complaint filed in Arizona federal court didn't request modest tweaks or gradual reforms. District Judge Sarah Henderson concurred, issuing a 73-page opinion in September 2024, finding suppressors clearly deserve constitutional protection under Bruen standards. That's when the actual war commenced, because the DOJ immediately escalated to America's most hostile gun rights circuit court. Ninth Circuit nightmare, the expected disaster. The Ninth Circuit Court of Appeals carries a reputation that makes Second Amendment litigators physically anxious. Before this ruling, the circuit had rejected gun rights claims in 23 consecutive cases following Bruen's June 2022 release. They upheld California's assault weapon prohibitions, magazine capacity restrictions, ammunition purchase background checks, and even bans on firearm advertising visible from public roadways. The 3-judge panel assignment worsened prospects dramatically. Judge Paul Watford previously authored opinions sustaining California's 10-day waiting period for all firearm purchases, including for existing gun owners. Judge Andrew Hurwitz penned the decision upholding Hawaii's public carry ban. Judge Jacqueline Nguyen had never voted to invalidate a single gun regulation throughout her judicial tenure. Gun rights organizations recognized they were entering hostile territory. The Second Amendment Foundation budgeted $280,000 for the appeal, anticipating circuit-level defeat and requiring resources for Supreme Court petitions. The Firearms Policy Coalition wargamed scenarios where the Ninth Circuit would not only sustain NFA provisions, but issue precedent so damaging it would actually worsen the legal landscape. Oral argument was scheduled January 28, 2026. Everyone anticipated catastrophe. The government's error confession filed January 20th meant oral argument never occurred, and instead of predicted defeat, Patterson secured total victory. What factors do you believe compelled the DOJ's position reversal? Internal legal assessment, political dynamics, or Supreme Court fears? Share your analysis in comments. The Bruen Standard. The test federal attorneys failed the Supreme Court's 2022 New York State Rifle and Pistol Association versus Bruen decision fundamentally transformed how courts evaluate gun regulations. That's exactly why the DOJ couldn't sustain suppressor defenses anymore. Pre-Bruen, courts applied a two-tier test. Does the Second Amendment apply? Then, does the regulation survive means end scrutiny, balancing governmental interests against individual rights? Bruen eliminated balancing completely. Justice Clarence Thomas wrote for the majority that the Second Amendment isn't a second-class right subject to interest balancing tests. Instead, courts must employ a text history tradition analysis. First, does the Second Amendment's plain language cover the regulated conduct? If affirmative, government must demonstrate the regulation aligns with the nation's historical tradition of firearms regulation from founding-era America. This framework creates an insurmountable obstacle for the NFA. Suppressors weren't invented until 1902 when Hiram Percy Maxim patented the first commercially viable design. There literally cannot exist any 1791-era suppressor regulations because the technology didn't exist yet. The DOJ attempted arguing that historical regulations of other hazardous items like gunpowder storage could serve as analogs, but Bruen's standard demands historical regulations be relevantly similar in how they burden rights and why. The government's Office of Legal Counsel invested 7 months searching for historical analogs justifying suppressor registration and taxation. They discovered nothing surviving scrutiny. A $200 tax on hearing protection equipment has zero historical parallel to anything from the founding period. That's why the DOJ had to confess error rather than defend the legally indefensible. The unanimous opinion, 3 pillars. Dismantling the NFA Chief Judge Jacqueline Nguyen's 89-page opinion is a constitutional tour de force that gun rights attorneys are already labeling the most significant Second Amendment decision since Heller. All 3 judges joined every section, making it binding precedent across 9 Western states. The opinion rests on 3 independent pillars, each alone sufficient to invalidate suppressor provisions. Pillar 1 addresses the common use requirement from Heller. The government contended that 2.6 million suppressors sounds substantial, but represents merely 2% of gun owners, rendering them unusual. Judge Nguyen demolished this by noting when Heller was decided in 2008, approximately 1.5 million AR-15 rifles existed in civilian possession. Yet the court specifically cited AR-15s as protected common-use arms. Pillar 2 tackles taxation as prior restraint. The court determined that $200 in 1934 equals $4,600 today, inflation adjusted. The average suppressor costs $600, meaning the tax reaches 8 times the item's value. No other constitutional right permits taxation at 800% of exercise cost. Pillar 3 addresses waiting periods. The court found that 9 to 12-month delays in exercising constitutional rights, with no maximum time frame and no recourse if government simply never processes applications constitutes de facto prohibition. Patterson waited 11 months for approval after already passing a background check requiring 15 minutes. The 90-day implementation order. Immediate changes. Judge Nguyen didn't merely invalidate law and create chaos. The opinion includes detailed 90-day implementation timelines, phasing out NFA suppressor requirements, while maintaining background checks through existing NICS systems. This is critical. It prevents the parade of horribles government always warns about when gun regulations fall. Effective immediately, as of January 23, 2026. ATF must cease collecting $200 tax stamps for new suppressor purchases. Anyone purchasing suppressors after this date pays only for the suppressor itself and undergoes standard NICS background checks identical to handgun purchases. No fingerprints, no photographs, no ATF Form 4, no Chief Law Enforcement Officer notification, and no waiting periods beyond instant background check processing. For the 347,000 individuals currently awaiting pending Form 4 applications submitted before January 23, ATF has 14 days from the decision to auto-approve all applications pending successful NICS rechecks. Within 90 days, ATF must refund all $200 tax stamp payments for applications submitted after January 1, 2024. That's approximately $69.4 million in refunds. Most significantly, the court ordered that all persons currently in lawful firearm possession are deemed lawful suppressor possessors without registration. This means if you legally own firearms now, you can legally own suppressors now. The NFA registry for suppressors becomes obsolete. Do you think this implementation timeline is achievable, or will ATF resist and generate chaos? Comment your predictions for when April 23rd arrives. The domino effect. Short-barreled rifles are next. The opinion's legal reasoning doesn't stop at suppressors, and the court understood this perfectly. Judge Nguyen included a 20-page section of dicta, statements not necessary for the decision but providing guidance for future litigation, that systematically applies identical Bruen analysis to short-barreled rifles and shotguns. The implications devastate what remains of the NFA. Short-barreled rifles, defined as rifles with barrels under 16 inches, have been NFA items since 1934. Government's historical justification has always centered on SBRs being concealable and therefore more dangerous than full-length rifles. But the opinion highlights that millions of Americans legally carry concealed handguns in all 50 states, after Bruen struck down May issue permitting. The opinion cites data showing approximately 4.2 million AR-15 pistols and braced firearms in civilian hands, all with barrels under 16 inches. These are already in common use for lawful purposes, including home defense. Judge Nguyen wrote, she could identify no principled distinction between an AR-15 pistol with a 13-inch barrel and an AR-15 rifle with a 13-inch barrel, except one requires a $200 tax and one doesn't. 3 separate lawsuits challenging SBR provisions were filed within 18 hours of the Patterson decision, all in the Ninth Circuit, to capitalize on binding precedent. Legal experts assign these cases a 95% success probability because the government already admitted they cannot defend arbitrary barrel length restrictions under Bruen. The state law complication. 8 states still ban suppressors. Here's the problem nobody's discussing. This is a federal court decision, invalidating federal law. 8 states maintain their own suppressor bans written into state criminal codes existing independently of the NFA. If you reside in California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, or Hawaii, you're still violating state law possessing a suppressor, even though federal law no longer prohibits it. California Penal Code, Section 33,410 makes suppressor possession a felony with penalties reaching 3 years state imprisonment. New York Penal Law 265.10 classifies suppressors as dangerous weapons with mandatory minimum sentences. These state laws were written mirroring federal NFA restrictions, but they remain on books as independent criminal statutes. However, the legal pathway is clear. The 14th Amendment incorporates the Second Amendment against states, meaning state governments are bound by identical constitutional limitations as the federal government. If federal NFA suppressor provisions violate the Second Amendment, then identical state provisions also violate the Second Amendment. The timeline for state-level relief is faster than most realize. California already has pending suppressor ban challenges stayed awaiting developments in federal NFA litigation. Gun rights attorneys estimate suppressor bans in at least 5 of 8 states will fall within 12 months. The machine gun. Question: Hughes Amendment under attack. The question everyone's asking: does this decision open doors to challenging the machine gun ban? The answer is complicated, but yes, challenges are already being drafted. The 1986 Firearm Owners Protection Act included the Hughes Amendment prohibiting civilian possession of machine guns manufactured after May 19, 1986. This created a closed registry where only approximately 630,000 transferable machine guns exist, driving prices to $15,000 to $40,000 for weapons costing $600 to manufacture. The constitutional analysis for machine guns is harder than suppressors because of United States v. Miller from 1939, which stated the Second Amendment protects weapons with reasonable relationship to militia use. Machine guns are clearly militia weapons. They're standard issue for every military force globally. But Miller also stated weapons must be in common use, and the Hughes Amendment has artificially prevented machine guns from becoming common by freezing supply for 40 years. Here's where Patterson creates an opening. The opinion specifically states government cannot argue something is unusual when government's own regulations prevent it from becoming common. Government cannot create scarcity, then cite it as justification. That exact reasoning applies to machine guns. Before 1986, machine gun registrations were growing at 15,000 to 20,000 annually. If that growth had continued, there would be over 1.2 million registered machine guns today, easily meeting common use thresholds. Second, Patterson holds that registration and taxation requirements constitute unconstitutional prior restraints. The Hughes Amendment doesn't just tax or register machine guns, it bans them entirely for civilians. If a $200 tax and registration violates the Second Amendment, an absolute ban certainly does. The Firearms Policy Coalition has confirmed they're preparing Hughes Amendment challenges to be filed in the Fifth Circuit, the most gun-friendly appellate court. They're recruiting plaintiffs who are FFL manufacturers currently allowed to possess post-1986 machine guns for dealer samples. This is the ultimate question. Do you think the Hughes Amendment machine gun ban will survive constitutional scrutiny after Patterson, or is the NFA completely finished? Comment your prediction below, because this is the most consequential Second Amendment question of our generation. The NFA is crumbling in real time, and most gun owners remain completely unaware this is happening. If you want to stay ahead of every major development in firearms law, hit that subscribe button and activate notifications right now. Like this video, share it with every gun owner you know, and don't forget to check out Firearm Legal Briefing for more constitutional analysis. I'll see you in the next one.